Hello, hi everyone, welcome to the webinar. We're just going to wait for a few more people to join and then we'll begin. Hello, hi everyone. I've got lots of participants already signed in, so we'll make a start, and I'm delighted to welcome you all to today's webinar. Really pleased you could join us. The topic of the webinar, as it says on the screen, is sexual relations and consent post-brain injury. And it's a topic we've chosen because we felt that it's often a sort of taboo subject and one that can be sort of ignored or overlooked. But we feel it's a really important aspect to look at a person holistically, including, relationships and sexual relationships. So we hope today's session will be really interesting and informative. By way of introduction, I'm Laura Murphy, an associate solicitor in the personal injury department at Leigh, but I'll just be chairing today. So it's my pleasure to introduce you to our speakers for today. First of all, we'll be hearing from my colleague Sophie in our solicitor in our human rights team here at Leigh. She's going to take us through the recent case of JB and tell us about the conclusions and findings of that case. And then we'll be handing over to our guest speaker, who I'm delighted is joining us, Clare Chiwandire, who's an OT and case manager at Independence Works. Clare and I did a webinar together last year about parenting post-brain injury, and this was one of the topics that came up when we were discussing in preparation for that webinar. We felt it would be a really helpful topic to cover, and Clare's got significant expertise in this area, so we're really pleased she was able to join us today. She's going to run through her experience of managing these issues, mainly as case manager on the ground, and strategies that she's adopted in the past or could be adopted. And then we'll hand over to my colleague Anna Moore, an associate solicitor in our human rights team here at Leigh, and she's going to be discussing the call to protection, and she'll run through some case studies talking about what happens when there's a disagreement about someone entering into a sexual relationship or not having the opportunity to do so. And then lastly, we hope there'll be some time for some questions at the end. If you have questions, please do pop them in the Q&A box, and I'll be keeping an eye on that. And we'll try to pick those up at the end, aiming to finish altogether by about 1:15. Okay, so I'll hand you over to my colleague Sophie to get us started. Thank you.
Great, thanks very much, Laura. I'm just going to share my screen. Okay. Hopefully, just need to wait for that to load, I think. There we go, phew. So, welcome everyone. As Laura mentioned, I am a solicitor in the Human Rights Department here at Leigh, and I often act in court of protection proceedings raising health and welfare issues, and I tend to act for P, who is the person who it is thought might lack capacity, with the OS, the official solicitor, acting as litigation friend. So what I'm going to do is I'm going to walk you through the judgment and also the potential implications of the case. JB, as some of you may already be aware, was a judgment handed down by the Supreme Court in November. It focused on the issue of capacity to engage in sexual relations, but because it was the first time the court had to grapple with the approach to assessing capacity, it took the chance to set out the general approach, which will have wider implications. So I think a helpful starting point is to identify the key issue which the court had to determine. And this was whether the information relevant to JB's decision to have sexual relations includes the fact that the other person must be able to consent and gives and maintains consent throughout. And if this was part of the relevant information, then in order for JB to have capacity to make the decision for himself, he'd need to be able to understand that information, to retain it, and to use it and weigh it in coming to a decision. If he was unable to do this, even after all practical steps have been taken to help him, he'd lack capacity to make a decision about having sexual relations. He'd lack capacity to make a decision about having sexual relations, and because under Section 27 of the Mental Capacity Act, a decision cannot be made in someone's best interest where they lack capacity to have sex, he would not be able to have sexual relations in the future. So, having set out the key issue, I think it's probably helpful to run quickly through the facts of the case. It's important to note that at the time of the judgment, a number of the facts hadn't been finally determined, but a lot of the evidence was agreed. So, JB was a 38-year-old man living in a supported residential placement where he was subject to a comprehensive care plan which imposed significant restrictions on his independence, including restrictions on his access to the local community. He could only go out with one-to-one supervision. His contact with third parties, again, he had to have one-to-one supervision, especially when in the presence of women, and on his access to social media and the internet. JB had multiple diagnoses, including epilepsy, which it was thought might have resulted in brain damage, anxiety, short-term depressive episodes and self-harm, and of particular relevance to the issues in the case, autistic spectrum disorder. And his autism had resulted in him displaying inappropriate sexual behaviours, including inappropriate touching and targeting of particularly vulnerable people. It also meant that he had significant difficulty in understanding how other people were thinking or feeling, and the need to adjust his behaviour in response to them. So of particular relevance, JB's autism meant that he had a marked deficit in using and weighing information about whether a woman would be giving and maintaining her consent throughout the sexual relations which he was desperate to initiate. What JB did understand was that he could give and withhold consent. He had a full understanding of the mechanics of sex. He understood that a woman might become pregnant as a result of sex with men. He understood STIs and the role of different contraceptives in preventing them and unwanted pregnancy. So in other words, he understood all of the information which previous cases had said was relevant to the decision to engage in sex. But what the evidence suggested he lacked was an understanding of the concept of consent by the other person. And as a result, it was felt he couldn't weigh the importance of ensuring his partner was consenting when coming to a decision. And when he was asked about the idea of a partner being able to withdraw consent, he appeared visibly shaken and responded, if the person gives consent, then she's already given consent and you have to go through with it to the end. This was obviously an issue because if the fact that the other person must be able to consent and give and maintain consent throughout was part of the relevant information, then JB would need to be able to understand, retain, use and weigh that information. And if he could not do so, he would lack capacity to make a decision for himself as a result of his autism. Another aspect of JB's factual circumstances, which was important, was that he was assessed as presenting a moderate risk of sexual offending to women. And as a result, he is at risk of prosecution, imprisonment, which was considered to have a significant impact on him in particular because of his autism, and retaliatory harm from friends or family of people who he had potentially assaulted. And the significance of this was that if the reasonably foreseeable consequences of JB deciding to engage in sexual relations when the other person is unable to consent or does not consent is that he could harm himself and the other person, then that too would be relevant information which he'd need to be able to understand, use and weigh. So how did the court go about grappling with the case? Well, it began by observing that the Mental Capacity Act adopts a functional understanding approach. Which means that the question to be answered is, does P understand the general nature and likely consequences of what he is deciding, and can he communicate his decision? And the judge highlighted that the test for determining capacity is set out in section 2.1 of the Mental Capacity Act, which I've put up on the screen, and that the remainder of sections 2 and 3, and they're quite long, provide supporting descriptions and explanations. But the key point is that there's a single test for determining capacity, and it requires the court to address 2 questions in order. So the first question, is P able to make a decision for himself in relation to a particular matter? And in order to answer this question, there are a number of stages which have to be gone through. And the first stage is correctly formulating the matter. So in the context of sexual relations, in JB's case, but in most cases too, the matter will be formulated in a non-specific way directed to the nature of the activity rather than the identity of the proposed sexual partner. However, the court was clear that it's wrong to say, as had previously been thought to be the case, that consent to future sexual relations can only be assessed on a general and non-specific basis. And the court said that in some cases, the matter will be person-specific. So, for example, in a case involving a long-standing monogamous relationship between two elderly people, one of whom develops dementia, you potentially only need to see whether or not the P in that case is able to understand the information with regards to their partner and not more generally. So once the matter has been correctly identified, the next step is to identify the relevant information to the decision. And this includes information about the reasonably foreseeable consequences of deciding one way or the other, or of failing to make a decision. The relevant information may differ depending on how the matter is formulated, as may the practical steps to help P make a decision, the reasonably foreseeable consequences of deciding one way or the other, and the potential for serious grave consequences. So, for example, if we return to our case of a heterosexual elderly monogamous couple, one of whom develops dementia, it may not be necessary to try and educate P on the role of contraception in avoiding pregnancy, as there won't be a risk of pregnancy on the facts of that case. So once the relevant information has been identified, P is unable to make a decision for himself in relation to the matter if he is unable to understand, retain, use and weigh that information or communicate his decision. And if it is the case that P is unable to make a decision for himself, then the second question to be answered is whether the inability to make a decision is due to an impairment of or a disturbance in the functioning of the mind or brain. There has to be a clear causative link between the inability to make a decision and the question of whether P has an impairment or disturbance in functioning of his mind and brain, and then go on to consider whether this impacts his ability to make a decision. And indeed, if you do this, then you're at risk. And I think I've seen this in practice, I'm sure Anna has as well, of falling into a trap about making assumptions about P's capacity simply because they have a particular condition. And the Mental Capacity Act is very clear that you cannot do that. So, having set out the approach to be taken, the court then went on to consider JB's case in particular. And it worked its way through various grounds for appeal, applying the approach it had identified. But I'm only going to focus on the grounds which are likely to be most relevant in practice for case managers. So the court began by formulating the matter, and it found that the Court of Appeal had been correct to recast the relevant matter as JB engaging in rather than consenting to sexual relations. And it said that this is how the question of capacity with regard to sexual relations under the Mental Capacity Act should normally be assessed in most cases. And the Supreme Court found that formulating the matter as engaging in sexual relations better captures the nature of the issues in a case such as this, where JB wishes to initiate relations with others rather than consenting to relations proposed by someone else. So having identified the relevant matter, it then went on to identify the relevant information. And I think the most controversial aspect of the judgment was whether the relevant information includes the fact that the other person must be able to consent to the sexual activity and must in fact consent before and throughout the sexual activity. The court said that the relevant information did include those things. JB was therefore required to understand, retain, use and weigh that information as part of the decision-making process. And the court found that on the information available, JB was unable to do this, and so lacked capacity to make a decision for himself because of his autism. But it sent the case back down to the Court of Protection for full consideration in light of the judgment, and it was anticipated that the judge in the Court of Protection might want to order additional expert evidence going to JB's capacity. So, stepping back, what firstly are the key points of the judgment and what are the potential practical implications? I think the first key point is that it's important to remember, and in fact I think one of the most helpful aspects of the case is that the Supreme Court took the opportunity to set out the proper approach in respect of assessing capacity in general. So i.e. the need firstly to determine whether P can make a decision for him or herself by formulating the matter, identifying the relevant information, and then assessing P's ability to understand, retain, use and weigh it to reach a decision. And then secondly, if having done that, it's decided P cannot make a decision for themselves, to consider whether this is because of an impairment or disturbance in the functioning of the mind or brain. I think a second kind of key point to come out of the judgment is that correctly formulating the relevant information is key. And one of the real concerns which was expressed by the official solicitor in this case, which I've heard articulated on a number of occasions since, and may indeed be a reason why a number of you are here today, is that requiring too much information of a person undergoing a capacity assessment risks setting them up to fail. And in this case, the court was challenged with that proposition by the OS, and it responded that they considered they were not doing this. The court stressed that he is simply required to understand that the other person must be able to consent and does in fact consent throughout. And the court then said that if this is cerebral or involving a degree of analysis, a decision to engage in sexual relations is necessarily cerebral or analytical to that extent. And then thirdly, I think a key point to note is that judgment certainly leaves open the door for tailoring the relevant information depending on the facts of a particular case. So finally, with the practical implications of the case, I think there are two that I've set out on the slides. And the first is for those of you involved in conducting capacity assessments and those involved in instructing experts to assess capacity. It's important to be mindful that the assessment should start with the functional ability of the person, whether or not they can make a decision before moving on to the diagnostic test. And what this means in practice is that a number of forms for assessing capacity, including, as of yesterday evening, the Court of Protection's own capacity assessment form, need to be updated and changed. And then a final, but I think a really key practical point is that previous capacity assessments may now need to be revisited, and particularly where P was assessed on a generalised forward-looking approach as lacking capacity, but there is some reason to think that in specific circumstances of their lives, the relevant information should be tailored and narrowed, which may result in them having capacity where previously they were found to lack it. So that's all I have to say. I'm going to attempt to stop sharing my screen and hand over next to Clare.
Good afternoon, I think it is now. I'm just going to share my screen as well. Bear with me for just a second. Okay, I will give that a minute to move into full screen mode. Hopefully everyone can see that clearly. Right, well, good afternoon, and I'm excited to be here to talk about sex, and it's a very interesting topic and I think increasingly relevant, not only in recent case law, but also in the context of movements like the Me Too. Consent has become an everyday issue. Hopefully you can take away from my presentation some inspiration and ideas on addressing the issues of sex and consent with your client over the next 20 minutes or so. But more importantly, I'm hoping that you'll come away with potentially increased confidence in talking about sex. So firstly, a quick overview, and I'm not going to repeat what Sophie has already covered rather expertly, but I'm working on the basis that most of my audience today, you have an understanding of the Mental Capacity Act, as well as a working knowledge of sex and consent. So I'm narrowing it down to the client's capacity to consent to sex themselves and their capacity to engage in sex, including the understanding, obtaining and ongoing consent of their partner. I've got a few caution notes here, and the first one is what we talk about as the frontal lobe paradox. When we refer to formal capacity assessments for the Court of Protection, I think all the solicitors and case managers understand what that means, but there is often that disconnect, that difference in what we see in practice on the ground, because we all appreciate, I hope, that a formal capacity assessment, particularly if it's in a room with a single person interviewer and devoid of any environmental stimulation, the client may perform and explain and weigh up and retain that information and respond in a slightly better way than they do on the everyday life experiences that we see. So what I always encourage case managers and therapists to do is sort of feed in the information to that capacity assessment, any neuropsychometric reports and assessments that have been done, speech and language assessments regarding communication skills, but really importantly, the observation, objective and subjective on the ground from the family, the carers, the residential home, if they're in one, those need to be summarised and shared into the person undertaking any particular capacity assessment. Okay, so taking back a step, I am here because of my experience rather than being an expert in sex. So that's my disclaimer. And just to walk you back a step, my first referral where sex was an issue was as a new graduate OT in Melbourne, and I was working in a plastic hand therapy rotation, and the consultant walked over a referral for scar desensitisation. Not a problem, I'm a hand therapist, I thought. And then it transpired that the scar was not on a hand, it was in the vagina and the groin of a young lady who had impaled herself during a storm on a broken mast of a boat and sustained sort of soft tissue trauma. I think what I learned very quickly is that we need to be able to talk confidently and openly about sex and sexuality with our clients. And I will spare the precise details, but after some conversations and a little bit of visual demonstration, but not in vivo, she recovered successfully using graded massage, stimulation and a desensitization program. No surprise, we're talking about masturbation, and she returned to sort of an active sex life. I then went on in the 90s to work in Africa, in Zimbabwe, and found myself doing HIV and AIDS prevention programs with young children, as young as sort of 9 or 10, all the way through to the end of their teens, and was also roped into working with the commercial sex workers there. Not a typical role for an OT, but again, I've done a lot of talking about sex as a result. So by the time I came to the UK and was working over 20 years ago as an OT and then subsequently as a case manager, talking about sex was part of my everyday assessment, particularly for community clients, particularly for brain injured clients. And I was somewhat surprised to find that we will talk to clients about their hobbies, you know, and they will happily talk to us about going skiing and list that as a hobby or one of their sort of activities of daily living, when in fact we're not talking to them about having sex. And statistically, NatSal, which is the big sort of activities and lifestyle organisation that does surveys in the UK, they reported at their most recent survey that on average, sort of sexually active adults in the UK are reporting having sex 5 times a month or 5 times over 4 weeks. I would suggest that a lot of our clients are skiing or going to the gym, and in some cases doing shopping or laundry less than they're having sex. So it needs to become part of our everyday assessment. Therefore, if you're talking about sex with your client, then you're a really, really valuable part of their puzzle and their sort of ongoing management. Okay. So what happens if we don't talk about sex? I haven't skipped a slide, have I? Just checking. So this is the consequences again that I think has been reported. We know if we don't talk about sex, we end up in situations where consent is an issue, where there's risky and vulnerable behaviour. But on a more sort of basic level, people that report lower sexual function scores, so that includes the ones listed on the screen, which I'm not going to read out in depth, but we're all probably aware of. Anxiety, pain, you know, practical performance problems. They're more likely to go on and report relationships breaking up, being unhappy in their relationships, finding it difficult to talk about it, getting STIs, or experiencing sex against their will, paying for sex, predominantly that's men, and having multiple partners, predominantly that's women. So we add that into somebody with a brain injury and borderline capacity, and you can see that this is a really, really important issue. So let's talk about sex. And I am an 80s girl in music, so here you go. You need to break the ice first. And I have found that I have experienced more tears as a case manager when I get to the topic of sex and intimacy than in any other area of the discussion. What's really important before you start, I find, is to make sure you're comfortable talking about sex. If you're not comfortable, then it's going to make it awkward for everyone and you're likely to get less from your client. Context is also really important. I like to explain to my clients that I have a few questions about their sexual function that I'm going to ask them to help understand if and in what way their brain injury might have impacted on their sex life. I pre-warn them during this assessment and I ask for their permission as to whether they want their partner, if they have a regular partner, to stay or be separated for that part of the assessment. If they do choose to have it confidentially with me, then I always try and get permission to sort of speak to their partner and get their view without necessarily disclosing theirs. That is really important. And I think the next step in your assessment forms part of what Sophie's just referred to as the relevant information that the court is interested in. No assessments of capacity and consent in relation to sex are going to be identical because the context and the breadth of what we're talking about is really, really diverse in this day and age. So I also give my clients permission to normalise discussions about sex. They need to understand that whatever their sexuality, sexual preference, sexual behaviours are, that is going to be normal and that's not going to shock you. So I often explicitly say that to them. I ask all of my clients this question, and that normalises it. I'm not singling them out. And I said, it's unlikely that anything you say is going to shock or surprise me because I've heard a lot in my years doing this work. And that tends to sort of reduce some of their anxiety. The next step is, before we get to these issues on the screen, is establishing a baseline. What was their sex life like before? Sophie really nicely explained the context of JB and his sort of issues. And I think that's where you start. And again, I would encourage everyone to ask specific questions. How often did you have sex? And I will give them an example that again normalizes their response. So I'll say, for example, were you having it 3 times a day, twice a week, once a month, once a year, or not in the last decade? And I can guarantee that if you say that with a slight smile and in a very blunt way, then you're likely to get an answer back that's useful. Bearing in mind, part of the capacity assessment regarding sex and consent has already started with you as a case manager bringing up this topic and seeing how they answer the questions. I then tend to go, I'm going to talk to you about the 3 Ps, and I break it down into separate aspects of sexual function and sexual behaviour. The first, libido, desire, fatigue. Those are concepts that hopefully we all understand, but I might ask, has their libido changed? Has their desire to have sex changed? Has their partner's desire to have sex or libido changed? Because partners often perceive their brain injured partner differently than they did before the accident. I ask them explicitly, have you tried having sex since the accident? You know, if it's a no, have you tried masturbating? I ask really blunt questions and make it clear that I'm comfortable. When we're talking about performance, again, I think we need to be comfortable asking them, can you get an erection? Can you sustain an erection? If they're a man, do you proceed to ejaculation? For women, lubrication. For everyone, pain, anxiety. Really break it down. When it comes to the libido and the desire and the fatigue, as therapists, we know there's sometimes practical things, you know, pacing, energy conservation. For performance, we might want to bring in specialists, so urologists or practitioners, GPs, otherwise, who can consider whether there's any sort of structural difficulties with their sexual function. I mean, I would say I have talked to GPs on clients' behalf or with them about using Viagra, gel, all sorts of things. I talk openly about personal practice and private time and your self-masturbation, and also about using equipment, or what I've referred to here in keeping with my P theme, props. And I've shared a nice little link at the end to a website that has some interesting equipment that the OTs and case managers might be interested to look at. The context and the relevant information is also surrounding procreation and protection. So is this client someone that is planning on further children? Have they finished having any children they intend to have? Are they understanding of, protection on a contraception basis, but also on a sexual health basis? Can they talk about STIs? Do they understand that? Do they look at you blankly? Right. So coming back to relationships then, I think before we can understand sex and sexual function, we need to understand what kind of relationships they are in or have been in. So you need to find out who the client's regular or usual sexual partner is, if that's not already obvious. So if they haven't got a girlfriend or a wife, I find out what was your sex life before? What was your relationship status? Did you have casual sex with people on Tinder? Were you someone older that separated and not actively sexual? If you do have a stable partner, how long have you been together? Was it pre-accident? Is it sort of a new girlfriend, depending on how early your involvement is? And what kind of non-sexual commitments did they share? So other than just the romance and the intimacy, are they financially linked? Are they linked by having children or shared children? The other options, of course, are you looking for a partner or a relationship, or are you looking for sex rather than a relationship? Those are really blunt questions, but they're all going to form part of the relevant information and context that Sophie's alluded to. For clients with potentially reduced capacity, or those with borderline capacity, the ones that we're talking about today, it's really important to ascertain whether they're likely to be the initiator of sex and sex-seeking behaviour, as is probably the case with JB, or are they going to be sought after for sex, whether it's by their partner who quite doesn't understand their altered abilities post-brain injury, or by someone they may be looking for friendship or a romantic relationship with online, but not having considered sex. So gender is really important, but not exclusively limited. You will tend to find that your brain injured clients who are women will have slightly different management strategies than those who are men. So where is the greater risk in relation to their capacity for consent? Is it for consenting to have sex, or is it for their capacity to understand and obtain consent of the partner they're having sex with? All of this has to be sort of really carefully assessed. And I would suggest that it's not going to be covered in a single session, but if you bring it up in your initial appointments and assessments, if that's appropriate, then it sets a really open relationship between the two of you for sharing information. I think it's also important to explicitly ask the question, are they likely to want to access online dating, and we can all appreciate there's different risks associated with that. Or also ask, are they likely to consider commercial sex? And there's a very interesting piece of case law that went to the Court of Appeal, April 2021, and there's a link at the bottom of that screen, which related to a client that was deemed to have capacity to consent to sex, but the debate was over whether the care home staff and the people involved in his care package could facilitate commercial sex. I encourage you all to read the law if that's where you're thinking you might help your client, because while prostitution's not illegal, paying for sexual services is. So if you as a case manager or a deputy for the court protection facilitate that, it gets a little tricky. I would always seek advice from the OPG if that was to happen, and I'm sure that the solicitors on the call can clarify that as well. So bringing that into sort of a summary, the key theme for me is let's all keep talking about sex. And if you're not already talking about sex, start talking about sex. We can't answer the questions that are raised in this recent case law of JB without really understanding that consent, capacity and relationships can all be fluid and changeable. Decisions are really situation specific and time specific. And as case managers, there's no set formula we might follow. There are some interesting ideas and information there. This is not an endorsement. Take from these what you will. The Brook Trust is quite an old charitable organisation. Lots of helpful information on sex and disability, etc., consent. Outsiders, the TLC Trust and Shada, they are again talking a little bit more about sort of commercial sex and access to that. Spots is the one for disabled clients who may have physical difficulties, and they have a lovely page on their website after you click past wheelchairs, wheels and spokes on sex aids, and I would encourage everyone to go and have a look in terms of interest, if nothing else. The Court of Protection, if you're a case manager working with a deputy where the case has already been, being supervised by a professional deputy, the OPG can be very, very helpful in answering difficult questions. One example that I've had personally is a client of mine who had capacity to decide that he wanted to have sex, and the consent for his partner was not particularly an issue because his interest was in accessing casual sex, and he was prepared to consider paying for it. The deputy and I became engaged with a long discussion with the OPG representative that was monitoring the deputy's input about the legalities of commercial sex in the UK, because where I was originally born, Australia, the law is a little different, so we can access legal sex services a little bit differently to how it happens here in the UK. And to cut a long story short, we ended up facilitating him to have regular holidays with support initially by brothers, family, etc., to Amsterdam, and a very generous daily spending allowance, because the legal nature of sex work in the red light district and places of Amsterdam kind of cuts out some of these issues that we're having to deal with today. I'm not recommending it necessarily, but I'm also saying keep your minds open, do your homework. Headway have a nice little blog saying let's talk about sex, and I'd suggest you go and have a look. I'm going to probably stop there and hope that there's some questions towards the end that you might have for me. Thank you for your time. I'm going to hand over now to Anna from Leigh, human rights specialist as well, and I'll leave it there.
Thanks, Claire. That was fascinating. I'm just going to attempt to share my screen. Hopefully that's all come up for everyone. So as Laura said at the beginning, I'm a solicitor working in the human rights department at Leigh. A lot of my cases involve applications in the Court of Protection. So for people who lack capacity to make decisions where the Court of Protection has been asked to make decisions for them, I act for P, the person at the centre of proceedings, and also family members when there is a dispute. In the next 15 or 20 minutes, I'm going to talk about what happens if there's a disagreement between those supporting an individual and how the Court of Protection can help, and also when you, as the person supporting P, should think about going to the Court of Protection. So I guess the context we'll be looking at here is really if someone you're supporting wants to enter a sexual relationship and you've got concerns about that, or if you're concerned about a person not having the opportunity to enter a sexual relationship and they want to. I am going to start by going back to basics, and so apologies for those who are familiar with the workings of the Court of Protection, but I do know from some of my cases it can feel quite daunting for those to be involved in proceedings if you're supporting someone. It's not always something that will come up or you'll have experience with as case managers or a deputy or any other role in supporting P. The other thing I'll touch on, but very briefly, is human rights, and whether, and just being alert to whether human rights are being put at the forefront of decision making and any breaches that might occur and what can be done about that. So first things first, capacity. And again, you will all have a good working knowledge, as Claire said, of the Mental Capacity Act, I'm sure, but I think it's always helpful to go back to basics and and remember that the Court of Protection, and also anyone before the Court of Protection gets involved, can only make decisions for someone if they lack capacity. And the starting point there is obviously the Mental Capacity Act, which sets out really important statutory principles that empower people to make decisions for themselves wherever possible. And then it also protects people who lack capacity to make decisions. And that's done by providing a framework, placing the individual at the centre of the decision-making process. So these principles include, as you all will know, that you're assumed to have capacity unless it's established that you lack capacity to make a decision. And also that all practical steps should be taken to enable a person to make a decision. Also, and I think really important when you're considering the context of sex, is that just because a person will make an unwise decision doesn't mean that they shouldn't mean that they're treated as unable to make that decision. Choosing to have sex with someone is probably the most personal decision you can make. And so a person might make a decision that you wouldn't make. They might live their lives in a way that you wouldn't live your life. But that doesn't mean that they can't make that decision themselves. A decision might also include an element of risk. And again, this is something to be carefully considered, but it doesn't necessarily mean that the decision shouldn't be allowed. And the court has confirmed that in various cases. Other basic principles that are important to keep at the forefront of your mind is that capacity is issue specific and can fluctuate. And Claire's already mentioned this. So someone might have capacity to make certain day-to-day decisions about what they want to wear or where they want to go, but they might lack capacity to make more complex decisions. So when you're talking about capacity, be specific in what you're referring to and be aware that it can fluctuate day to day. I've linked at the end of my talk a couple of resources that I find useful, and one of them is the Mental Capacity Act Code of Practice, which does offer practical guidance and talks through certain scenarios. So if you are unsure, we have questions, it's a good place to start. So Sophie has talked us through JB and how that has changed and refined the test for capacity to engage in sex. You also, when you're thinking about whether a person has capacity to engage in sex, will still need to think about the test for them to have contact with people. Again, we're talking about potential scenarios that a person wishes to start a sexual relationship, and you might have concerns that they don't have capacity to make that decision themselves. And if they don't have the capacity, is that a decision in their best interests? And I'm talking about contact here, because if a person lacks capacity regarding sex, a decision will never be in their best interests. So Sophie has talked about the decisions in JB that confirms, and this is a principle that's always stood, that a decision can be made in the abstract. So just because a person doesn't have a partner lined up, or no one immediately identifiable, doesn't mean you shouldn't start thinking about and talking to your clients about sex. And Claire has, I think, really excellently demonstrated how you can approach that and doing it in an open and frank and honest way. So because the test to engage in sex is still, I say test, the relevant information for the capacity test to engage in sex is different to the relevant information you have to consider for having contact, you do have to consider both, and these decisions come arm in arm. In JB, it was floated as to why are these separate decisions? Why can't there just be one decision about a person having contact, and that contact might involve them having sex with someone? But the court decided to keep the relevant information separate. So you do have to consider both. The court has helped us out when you're looking at contact and looking at what the relevant information will be when considering someone's capacity. And so I've listed them on the slide, and these are things that you would want to talk to your client or P about when you're assessing their capacity to have contact. And the relevant information includes who the contact will be with, so the person or the category of people, the nature of the relationship between P and the person that they want to have contact with. And this is in broad terms. So is it a friend? Is it a family member? Is it a boyfriend? Is it a stranger? And what sort of contact are they wanting? So where will it take place? Will it be in a cafe? Will it be at home? Will it be in a nightclub? Will the contact be alone? Will it be supervised? And how long will it be for? Will it be a couple of hours? Will it be overnight? Will there be a support worker present? The court will want to know that you've discussed all of these things. You also need to think about the positive and negative aspects of having contact. And again, this is a broad discussion, really seeking to bring out P's understanding of that. And linked to that is any risks posed to P by the person that he or she wants to have contact with. For example, do they have any previous criminal convictions? Even if there is a risk, as I said before, it doesn't necessarily mean there shouldn't be contact. What there needs to be here is a discussion of the person's understanding of that risk. So when you're thinking about sex, I think the risks that you would maybe come up against is there a power imbalance here? Is there any aspect of coercive control? Is there any aspect of using sex for financial gain? These need to be fully and sensitively explored. There are also factors that are not relevant when you're considering the information required for the test to consent to have contact. And that includes the nature of friendship and the importance of family ties in general. And the reason that that's not relevant is that there's a concern that the assessor's values might be imported into any assessment if that's taken into account. Also, and it's an obvious point, but consequences that are not reasonably foreseeable to this decision. So long-term impacts that can't be linked, or you can't see that they'd have any consequences here. And also risks that are not an issue in a specific case. So you don't have to undertake a consideration of whether there'll be financial abuse or assault if they're just things that won't come up in this particular circumstance. And again, these factors are all set out in the case of LXB, which I've linked at the bottom. I'm not going to go into this slide in any detail, but just to reference it, because as Claire talked about, contraception is also something you will want to consider when you're talking about sex. And there is, again, separate information that is relevant to consider when you're assessing someone's capacity to make decisions about contraception. And again, the court has helped us out by setting out what that relevant information is and what irrelevant information is. And that's set out in a case, again, cited below, and it's a local authority in A. And it's quite, what's the word, straightforward. They're sensible factors, but they're worth going through. And so it's, again, important that when you are doing capacity assessments, that they are issue specific and you're looking at the relevant information for each assessment that you're doing. And the court has helped us by saying what that relevant information is. I wanted to go on to talk about a case that I was instructed in, that was a long-running and complex case over a number of years. And in this case, we had to think about sex, contact, and contraception. And I think it illustrated just an example of how these issues can be dealt with by the court. I acted for CF, who was 28 years old when we met. She really wanted a boyfriend and put herself in really risky situations over the years where she had suffered rapes, physical abuse, and sexual assaults. CF had a diagnosis of EUPD, which is a type of personality disorder, and learning disabilities. The concerns arose from her use of dating websites and apps where she would contact people and at a very early stage disclose that she had a learning disability, which made her fall prey to predatory men. I've seen some of the messages that she sent, and she would disclose that she had a learning disability, and then some people would be straight round to her door seeking to have sex with her. Her mum issued proceedings in the Court of Protection, seeking to restrict her contact with strangers that she met online for really understandable reasons. The court found that CF lacked capacity to make decisions about contact, also lacked capacity to make decisions about internet use and social media, which again is another thing to consider when you're thinking about people's sex lives and dating lives. The court concluded that she had capacity to consent to sex, which is how the test was framed at the time. And with work, she also gained capacity to make decisions about contraception. At the beginning of the proceedings, the court put in place restrictions on her contact with men, but they were lessened over the course of proceedings. And during the proceedings, which lasted a couple of years, she met a man who became her boyfriend, and she was supported to have contact with him. And this was done by a combination of education about safe sex and safe relationships, and also detailed plans and protocols were put in place about their contact and about her internet use. And eventually they were able to spend time alone, and the restrictions got less and less and less. The final hearing in this case was contested because her mum didn't agree with the lessening of the restrictions. Her mum was, as I say, understandably terrified that she'd find herself in the situations that she had been before. But acting for CF, with the official solicitor as her litigation friend, we supported the lessening of restrictions. She had got to a point where she was doing incredibly well living independently and becoming independent, and she was well supported. There was obviously a risk in the decisions that were in lessening the restrictions, but the official solicitor felt that that was necessary to enable her to live the life that she wanted. So we've spoken about capacity and that there are different tests, so different information that you have to look at for different types of issues. The next stage really is, what if someone lacks capacity and there's a disagreement about what is best for them? And so this is when you might want to consider whether the Court of Protection can help you. The Court of Protection is there to make decisions in someone's best interests, and so it can be asked to do exactly that. As a case manager or someone supporting a client, you might wish to bring these things to the attention of the court, and you can do that by issuing proceedings yourself, but more commonly, it should be the responsibility of the NHS Trust or the local authority who has overall responsibility for supporting P to make the application. But in my experience as a case manager, you may well have more idea about what is going on the ground rather than the local authority or the trust. Sometimes there might not even be an allocated social worker. So if you have concerns, or if you know that there is an area of disagreement, do raise this. And I think one of the best ways of doing this is by convening a best interest meeting to get this on the agenda and making sure that everyone who should be involved is invited to express their views. And it's really where I've come across it is that case managers are really effective at getting these issues on an agenda and pushing these, because sadly busy and overstretched local authorities can be quite slow in acting, and so you can play a really crucial role in this. Clearly it's good to try to avoid court proceedings if you can, but sometimes they are necessary and not to be unduly worried about, especially if the decision is particularly complex, or if you feel as the people supporting P you will never be able to make a decision that P will be happy with. In those cases, it would be appropriate to seek the guidance of the court. And this happened in one of my cases, AB, which I dealt with a number of years ago. But I think it's a good example of everyone working really collaboratively, but still where it was necessary and appropriate to have the courts making the decision in the end, because it was difficult. When I acted for AB, he was 21 years old. He had a learning disability and ADHD. He had a history of criminal offences that arose from looking at inappropriate images online, and because of that was placed on the sex offenders register. His social worker determined that he lacked capacity to consent to sex at the time and contact. But we sought expert evidence from a psychologist who determined he did have capacity to consent to sex. I query whether, looking at the new test or the updated test in JB, whether he would have still had capacity to consent to sex. But at the time, that was the evidence that was accepted by the court. AB was desperate to start a sexual relationship with his girlfriend, who had her own vulnerabilities. They'd been in a relationship for a number of years, and AB had expressed this wish for a while, and it also appeared that his girlfriend wanted this, although I didn't act for her. AB's care team hadn't progressed this. They were concerns about the risks that he posed to her. There were also risks to him in this, in that she would sometimes make allegations against him that turned out to be false. And so because of this, they were prevented for a number of years from starting a sexual relationship, even though they wanted to. And the court was then asked to decide whether they could spend time alone. And so through the proceedings, with AB being represented, a plan was worked out as to how this could be enabled. And it took really careful planning. It's not easy always, but we had to work with AB's care team and with his girlfriend's care team. And with that, a plan was put in place, and they were able to spend an increasing amount of time alone. And by the time proceedings ended, it seemed to be working really well. One thing that I also wanted to touch upon, as I said at the beginning, is whether this delay in enabling AB to start a sexual relationship constituted a breach of his rights under the European Convention of Human Rights. And potentially these issues can. So Article 8 is the right to a private and family life. And so your ability to express yourself by having a sexual relationship clearly engages that right. And potentially it could breach it if you are prevented from doing so. And that's something to be alert to, because that can lead to standalone claims, and it's a really important aspect of life. And so the court does take it very seriously. In AB's case, for a number of reasons, it wasn't possible to progress that type of claim. But I mention it because it's something that I think is really worth being alert to, because I think happily, people are more comfortable about talking about sex and enabling people who have brain injuries or other vulnerabilities to have that part of their life. But historically, people really used to shy away from it, and that definitely happened in AB's case. It was very hard, and his care team just thought it was too difficult to start to consider, and so that meant it got put off for a number of years until the court got involved. So we've talked about if you need to go to court and ask the court to make a decision. I thought I'd briefly conclude by talking about what happens at court. I know it can be quite unfamiliar territory, and so every case will be different, but there are a few things that will always happen, and I think it's good to be aware of if you are going to be part of court of protection proceedings supporting someone. So initially the court will make a set of initial directions, which are next steps for how things will go. So they will decide who needs to be a party, so who are the people that the court needs to hear from. And then P, the person at the centre of the proceedings, who will represent them. So a P might lack capacity to conduct the proceedings themselves, and if so, they need a litigation friend, which is often the official solicitor. P being a separate party is a really important part of court of protection proceedings, because it means that their voice is put before the court and their views independently of anyone else. And so it's really a crucial part of the decision-making process. The court will also want to know what evidence is needed and from who. So do you need more information about capacity? Do you need further assessments? Do you need more evidence about the facts about what's happening? And as a case manager or someone supporting P, you might be asked to provide some evidence. And again, it's nothing to be unduly worried about. You might be asked to attend court sometimes, and that can, I know, feel quite unfamiliar and daunting. But I think it's worth remembering these proceedings are not one party against another. It's every party trying to make a decision in P's best interests. So all the court wants to know is what is happening and what information you can provide that will help the court make a decision. The other thing that will happen is that there will be hearing dates set down, and there may well be a number of hearings in these types of proceedings. And one of the things to consider, especially if you are a person supporting P in these proceedings, is what role they will have in the proceedings. So do they want to come to court and attend the hearings? Do they want to meet the judge? Would they like to meet the judge in court, or could we ask the judge to come and see them at home? Judges are more and more willing to do that. And would it help P to have a remote hearing, which is a thing that has happened since the pandemic but has worked really well for some of my clients? Or would they prefer to go to court and be there in person? As someone supporting P on the ground, your input could be really valuable in making these decisions and working out how best to support P in these proceedings, because they are at the centre and the court is being asked to make decisions that are crucial to their life. Do seek advice if necessary if you are asked to attend proceedings or give statements, but I really just wanted to reassure anyone that is facing that it's nothing to be worried about, and it's actually a really important part of best interest decision making for P when required. I wanted to finish by just linking some materials that I found useful when thinking about this issue, and the first is an easy read version of the JB judgment. I certainly found it really helpful. You might find it helpful, and some of your clients might find it helpful as well. And I also wanted to highlight the Open Justice Quarter Protection Project. Again, I'm not affiliated at all, but it's a resource that I find really helpful. And it is an organisation who report on quarter protection hearings and the working of the quarter protection, and then blog about what happens at the hearings. It's trying to take away some of the perceived secrecy of these decisions being made, and perspectives are taken from a wide range of people, so witnesses, parties, observers, as to how quarter protection makes decisions, and it's well worth a read. They're on Twitter. And again, the Mental Capacity Code of Practice is there just as a resource that you might find useful when making these types of decisions and supporting P throughout. I think that's everything, unless anyone has any questions.
Thanks ever so much, Anna, and to all three speakers. I think that's been fascinating. I'm sure we could talk in much more detail on all of the topics. We've got one question to kick off the Q&A. So I think this is mainly for you, really, Claire. How would you start having this type of detailed discussion about sex with a client who's had a brain injury, but as a birth injury? And the writer says, or is that a whole different webinar? But Claire, be interested in your thoughts on that. Oh, you're on mute. That's it. Thanks, Claire.
I think it's a really interesting question, and I think one of the questions I would have in return would be surrounding the age of this client. My personal view, and there's lots of good resources out there for organisations like Scope and the Child Brain Injury Trust. I think normalising conversations about sex at an age-appropriate time is my guideline. And you start with normal puberty discussions and body changes, and consent about your body starts around that 11, 12-year age mark for most normal sort of preteens. The conversations emerge as they would with a normal parent. And I think what would be most frightening is if that client has reached an adult age without sort of having had step-by-step engagement in their sort of physical changes and their emerging sexuality. We all, hopefully, those of us who have parents or who've worked with adolescents will know that the interest in sex, can start from 12, 13 years old. And that is the age where consent should be one of your first discussions. Go and look out for the resources that are available for sort of mainstream society and choose those. Some are pitched very age appropriately, and the images aren't too childlike. And I would suggest that case managers should be having those discussions, obviously with the inclusion of the parents because they're a minor, but with heavy encouragement that they're allowed to explore that from an age that's appropriate to their peers.
Great, thank you, Claire. I've got another question here. As is really for Sophie and Anna, did the Supreme Court comment on best interests in the matter of engaging in sex? I'm assuming that's in the JB judgment.
So I think, the key thing to bear in mind with sex, I think Anna touched on this in her talk, is it's not something which you can make a best interest decision about. So whereas there are other types of decision where should someone live, for example, where if they can't make that decision for themselves, it is appropriate to make a best interest decision on their behalf. With sex, it's all or nothing. If you have capacity to have sex, then you can have sex. If you lack capacity, then you can't have sex. You can't be facilitated to have sex, and that's why the issue was so important, and the ramifications of the case on Jay, who was desperate to engage in a sexual relationship, were you know, huge, because that's now just not assuming that the case goes the way that I think it's anticipated it would go, that he lacks capacity, then that's something which won't be an option to him. So yeah, I think that best interests needs to kind of remain separate from capacity, and in the case of sex.
I think where best interests, and that's completely right, I think where best interest can play a part is that if someone has capacity to consent to sex, but they actually can't, they haven't been enabled to be in a situation where it would happen. And that's where the contact test also comes in. So you might well have capacity to consent to sex or to engage in sex, but you might not have capacity to make decisions about contact with certain people. Like my client CF, she had capacity to engage in sex, but the court found she lacked capacity to make decisions about contact with these people that she was meeting online. And so that's when the best interest decision can come in about how that contact is managed, which is why, as well as thinking about the capacity test for engaging in sex, contact, contraception, internet and social media, these things all feed into it as well.
Great, thank you. Couple of questions for you, Claire. Can you recommend any good resources for the current position on, in brackets, not facilitating sex workers for clients, please? Oh, Claire, you're on mute, sorry.
Right, so I refer you to sort of the links I put in my presentation. I think that the TLC Trust is quite a good resource for finding out a little bit more, but I'd read the case law, and I would be having, it depends whether your client's already a protected person under the court of protection. If they are, that almost gives you a little bit more flexibility, because sometimes the test is, if they've got a deputy for finances, because you're looking for commercial sex, it's how the deputy is approving a financial spend and how that's managed that gets case managers into that grey area, for better or for worse. I'm happy if you look at my details on Independence Works to share some information offline. Perhaps that might be the most appropriate way and explore it further. But yeah, I think it's something that I wish the UK would sort of relax on. But yeah, the TLC Trust, there are women who go into care homes in twin set and pearls, I think, but the law, it doesn't have to prosecute, and sometimes I think chooses not to. But as a case manager, I don't think we can put ourselves in that position, sadly.
Great, thank you, Claire. This is for Anna and Sophie. What do you think is the biggest wider impact of the judgment in JB, and what that will be?
I think there are a couple of things. I mean, I think certainly Anna was touching on earlier that there will be individuals now who previously were thought to have capacity to engage in sexual relations, where that will no longer be the case. On the flip side, there will potentially be individuals where on the previous kind of more generalized test, they were felt to lack capacity, but actually if their circumstances are appropriate to the question being formulated in a slightly different way, or the relevant information being tailored to their case, they may now have capacity. And I think the general key thing which I would take from it is that you do need to think, you know, very carefully about whether or not your the person whose capacity you're assessing fits within the kind of general framework of the first test, general formulating capacity to engage to sex, and then whether or not all of the relevant information set out in the case law applies to them. Because if not, and if there needs to be a modification to either the formulation of the test or the relevant information, actually that can have a really significant impact on whether or not someone does have capacity to consent to sex, which was the case in JB. You throw in one more factor, the other person's ability to consent, and suddenly he moves from being someone who we're very confident would have had capacity to have sex to someone who doesn't. So I think that's kind of one of the key things that I would take away. And I think on a more general point, the court was very clear about the need to about the approach to be taken to assessing capacity. So you first of all determine if someone can make a decision for themselves, and then you think about whether or not, if they can't, that's due to an impairment in the functioning of their mind or brain. And I think the court is clearly hoping to get people to focus much more on the assessing of the decision. And I think, as I said in my talk, we certainly have seen a tendency in the past for there almost be, quite lazy capacity assessments at times, where someone presents with a certain condition and there isn't necessarily the careful thinking that you would want. And I think that the court was very keen to stress that no, you need to do this properly, you need to formulate the question, you need to identify the relevant information, you need to think about whether or not he is able to make that decision for himself. So hopefully a renewed focus on that.
Great, thank you. And I think probably just one final question that's just disappeared. So you may have typed an answer, Claire, but I think probably general, and seeing as how passionate you were on the subject, just how can people on attending the webinar get more comfortable starting the conversation on sex? I mean, as you were speaking, I was thinking of myself and some of the initial meetings I have with clients when you're sort of building that rapport with them when you first met them. You know, when should they be raising this? Is it from that first meeting, and how do they go about it confidently?
Yeah, I think it is. And I'm lucky that I get a bit of practice doing my expert work as well, and sex always comes up. I think as a practitioner, we all have checklists of how our initial assessment is. And as with health backgrounds, we often talk about their cognitive function, their psychosocial function, and their sort of impairments. And then we move on to their activities of daily living. And I would urge everyone to just see sex as another activities of daily living. And I use the example of skiing or golf or laundry, whichever fits comfortably with you. We all say, well, who does the laundry in your house? How often do you do it? Or, they say, one of my goals is to get back to going skiing. And we put hours and effort into that as case managers when, as I said, they go on a ski trip for 1 week a year and we don't even bring up. And I had one client that I asked, and the daughter was sitting there, and he said, no, it was fine. He's saying that she stayed. And he said, when I said, how often are you having sex with your girlfriend? Because it was apparent he was having a relationship with somebody across the courtyard in this housing estate they lived in. And he said, oh, about 4 times a day. And he was 74. I remember looking at the daughter thinking, is this the brain injury and the cognition? And she goes, yes, no, that's so true. It's so annoying. And they're not even quiet. He got himself Viagra. And you don't ask, you don't get told. But I think the more you ask those, and that may have been one of those occasions where I did get a tiny bit shocked. But, once that's happened, the next time you ask, you're ready for that. And I think it's practice, practice, practice. But see it as a daily living activity, as a normal part of our humanity.
Brilliant. I think that was a good note to end on. Thank you again so much to our speakers, Sophie, Claire and Anna, and thank you for joining us. It's been a pleasure to speak. I know that there is, as I said at the beginning, many more detail that we could go into on these subjects. So if any of you have specific topics that you think would be helpful, useful for future webinars, please do get in touch to let us know. We'd be happy to hear your feedback. We will be sharing the slides and a recording of today's webinar on our YouTube channel next week, if you wanted to go back and look at the resources that both Anna and Claire have referred to. But otherwise, thank you ever so much for joining us, and have a lovely rest of the afternoon.